Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
I am very happy to be here with you in the second part of this series on litigating personal injury cases in federal court. Today, we're going to talk about one of my most exciting topics that I really enjoy as far as practicing, and that's conducting depositions in federal court. And we're going to talk about expert depositions because that's something that's a bit unique to federal court practice that we don't do in state court. Just a few things before we get underway. First, as far as resources, please consider me a resource not just for this CLE, but for anything. If you haven't joined me for a complimentary 30-minute Zoom one-on-one, please do so. I'd love to chat with you about anything and everything. Also, my podcast, if you may be listening to it now, if you're not attending the live CLE, but I have a podcast that has all of my CLEs on it, lots of interesting interviews and discussions in the areas of law and sometimes sports cars and other topics of interest. And I have 2 books on Amazon. Again, all proceeds go to my charitable causes. The one book is on litigating a personal injury case. The other is on trial skills. You can get and find all this information by scanning this code right next to me with your phone. Just open up the camera, scan it, click on the button. It'll give you a link to everything. All right. So now let's get to the reason that you're here today. Let's get to talking about depositions in federal court. So the difference in federal court from state court, at least New York State practice and most state courts, is that you don't conduct depositions of experts in state court. Some states I know you do, but New York, where most of you are, we do not conduct depositions of experts. You're not allowed to, absent court order or good cause shown. So that is something that's very unique and exciting, and I'm going to talk a lot about that today. The other thing that is a little bit different is some of the tools that are available to you for designating a deposition and for how the witness is going to be produced. So generally in state court, we will serve a deposition notice and then we proceed from there. Under the federal rules, this is all governed by Rule 30. Depositions fall within Rule 30 of the Federal Rules of Civil Procedure. And as I mentioned in part 1 of this series, you need to be a good rule follower to be in federal court and to be successful in litigating in federal court. If you don't follow the rules, that's when trouble happens. So you always want to start with going to the rules and then keep checking them. Make sure you're doing everything the right way. I still double check the rules because there's a lot of them on everything that we do throughout all of our federal cases that we regularly litigate at our firm. So take a look at Rule 30, and you don't need to look now, but I did. It's one of the documents that's not in the materials, but I put it in the chat. If you're listening to this via podcast, just shoot me an email, and I'll be happy to send you Rule 30. You could also Google it. Just type in Rule 30, the Federal Rules of Civil Procedure. And Rule 30 governs depositions, governs the type of notices. So when you are demanding a deposition in a federal case, you're serving a notice, and the preamble should be a demand for a deposition of the witness you want pursuant to Rule 30. Now, what's interesting is that there's something within Rule 30 in subdivision B6. And so some of you have heard of Rule 30B6. It's a common phrase that's thrown around, 30B6 deposition, 30B6 witness. And here's what it is. You all have probably run into a scenario where usually on the plaintiff side, you are suing a company for an accident that happened, maybe on their premises or in their vehicle, and they will designate and produce somebody for a deposition from the insured side, the defense side, and they get to pick generally who they produce. And sometimes it's a person without any knowledge of anything, and it's a waste of everybody's time. And I hate that. And the response I usually get is, well, they're a manager, they're a principal of the company, and we get to choose the first witness. I'm about being practical. I think most of us are, and it's always best to get a witness who knows something. Otherwise, why are we wasting our time? That's where Rule 30b-6 comes in. Rule 30b-6 is a tool that's used if one of your defendants in the case is a company or a corporation. And you know you need answers and you need information about something, but you don't necessarily know the witness. So you can't designate a specific witness because during the discovery process, you're going to try and find out who's the right person to talk about the records, the files, the process, the maintenance, whatever issue it is in your case. So, for example, I was litigating a fire injury case in federal court, and it was against Co-op City and the company that owns and manages Co-op City. And I needed a lot of information about the smoke detectors, what type were installed, when were they installed, who installed them, all kinds of things like that. And I didn't know who in Co-op City to ask for. They have hundreds of employees. So here's where you use a 30b-6 deposition. And what that is you serve a notice pursuant to Rule 30b-6, and that a sample notice I gave you in the chat, again, not in the materials. If you're listening on my podcast, just shoot me an email and I'll send this notice sample to you. But what it says is, in essence, we hereby, company, are demanding that you produce a witness with knowledge of the following. And then you list it all. You list, let's use my fire case as an example. What smoke detectors were installed in my client decedent's apartment? When were they installed? Name, manufacturer. How many did you purchase? Who installed them? Who is in charge of overseeing the installation? What records do you have of the installation? Literally, you put them point by point in the 30b-6 notice, almost like a DNI or a discovery and inspection notice we would do in state court. You're going to put all the areas of inquiry that you would like answers from this company, corporation, or commercial entity, and you're asking them to produce a witness with knowledge of all of this information. And the key is that it doesn't have to be someone with personal knowledge. So in my fire case, they don't have to produce the person who installed the smoke detectors or even someone in charge of that process. But they need to find someone that they can designate within the company, a representative from the company, who, if that person doesn't have personal knowledge of what you're hoping to learn and all the points you list out, they need to seek out and speak to the people within their company and gain that knowledge and make efforts to come to the deposition with answers to your questions and to the points that you've raised, the areas that you've raised in your Rule 30b-6 notice. And if they don't produce someone with knowledge, and if that person hasn't taken steps to go through and try and get answers to all of that, the law firm and the party can both be sanctioned for failing to properly comply with Rule 30b-6. There is clear case law on it. So the way that you would do this is you would serve the notice, the 30b-6 notice. They would produce a witness. You actually mark the notice at the deposition. You show it to the witness. Have you seen this before? Half the time they say no, which is amazing to me. And you're going to lay these foundation questions to make a record so you can go to the federal magistrate or federal district court judge and raise the issue. And ask them if they've reviewed it. Ask them if they looked into points 1 through 12, 1 through 5, 1 through 20, A through B. Did you look at all of these? Did you attempt to get information responsive to these areas of inquiry? And if they say no, that's a problem. Then you can make a motion. If you're the one requesting this deposition, you can make a motion to the court for sanctions, to pay for the court reporter, for your time, for your preparation, and for them to produce somebody else. And if you're on the receiving side of a 30b-6 notice, you don't want that. You don't want to be within the wrath of a federal judge for not complying with Rule 30b-6. So if you're on the receiving end, either as a plaintiff or as a defendant of a 30b-6 notice, or a co-defendant, co-plaintiff, whatever party you are, if you represent a company in that action in federal court and you get a 30b-6 notice, you need to find somebody within the company who's your client and give it to them and say, you go get answers and get as much information as you can. And if you can't, I need to know what steps you've taken to try and get the answers to all of these points, because otherwise I don't want to be yelled at by a federal judge and be sanctioned. So that's Rule 30b-6. It's a really great method for getting information that you need in federal court litigation, because as we know, there's many times where we're just grasping and we're trying to get more details, more information, and every witness says, I don't know, not my department. I can't give you an answer to that. And then we as litigators spend all this time just trying to find someone to question after going through people who don't know anything. So the 30b-6 is a really good tool, and I encourage that you look into it and use it where appropriate. Now, by the way, please ask whatever questions you want of me in the Q&A. All right. And what I will do is when I take a break I'm going to share from our sponsors in a little while towards the middle part or end part of this presentation. I'll take a look, see what I can answer while it's ongoing. But otherwise, from 2 to 2:30, I'm going to get to everybody's questions. And usually there's a lot of questions about 30b-6, so I'm happy to look at those. And I see there's a bunch of questions in the Q&A already, but I can't look at them just yet. So I will when I have a moment. Now, let's talk about, before we get into conducting the deposition and directing witnesses not to answer and all that nonsense that goes on, let's talk about why we want to take these depositions, why it's so advantageous in a litigation to be able to take the deposition of someone. We all know it is in our state court practices. It's always important to get material, to find out facts, to get information. But here in federal court, where you can question the adversary's experts, it is a gift. It is a discovery gift. Most state courts you can't. And here in New York State, we usually don't find out what our adversary's expert is going to talk about until, the eve of trial, or 30 days before trial, or 60 days before trial. After discovery is done, after we've tried to settle a case, we don't have much as far as expert information. We get some preliminary disclosures in state court pursuant to CPLR 3101D1 that have to give a general idea of what the witness is going to talk about, but we don't have to get a lot more, and we don't usually. So we don't know, is our adversary's expert going to carry the day? Are they as good as they appear on paper? Are they as good as their curriculum vitae? Do they make a good witness? Will they do well under cross-examination? Will they present well? We don't know any of this for the most part when we're going into trial, but in federal court, we do. And what's great about this is that we can really dig deep into the experts' opinions, and we can take them down, and we could make headway with experts. We can size the expert up, see if our adversary's expert will be good on the stand or not, see if they can back up what they put in their report, see how much knowledge they have in the area that they're opining on. Basically, see whether or not their purported testimony to come at trial is really worth anything or not. And that goes into evaluating the strengths and weaknesses of our case, right? We want to know not just that, does the other side have an expert, but is the expert good? And what will happen is in federal court, there will be a deadline. We spoke about this in the case management order. There will be a deadline given for expert discovery. And during that discovery schedule, there will be deadlines for exchanging expert reports. So just to rehash what we learned in part 1 and to clarify it, that each side to the litigation, plaintiffs and defendants, co-plaintiffs and co-defendants, if they are planning on calling an expert at the time of trial on liability, on damages, doctors, engineers, whatever kind of expert you're going to call, you need to submit a report to the other side within the time frame that the court sets. And that report has to be very detailed. It has to contain all their opinions, what they reviewed, what their references are, that they're citing to, what their opinions are. Because if it's not in that report, they're blocked and they're barred from doing that at trial, from offering such opinions at trial. It has to be in their report or a supplemental report. If it's not, then they can't come to trial and offer opinions that weren't provided in the report. So the report is really important for the party that's producing the expert to make sure you have a good report and your expert includes everything. But then there's the opportunity to question the person who authors that report, to question the expert. And I've always been amazed at how I will receive an expert report from my adversary and I'll read it and it'll seem really impressive and all kinds of charts and data and graphs and references and opinions and all these things that are just looking at face value are just going to crush our case. Oh my God, they've got a good expert. Look at this report. Look at these images and data and slides. Whoa. But then when you really start to roll up your sleeves, look into that report, peel the issues away, dig into it, find out what if it's just nonsense? What's actually based on real data from the case? What's these graphs and videos, are they just something that the expert came up with? Does this exist before this case? Is it reliable? Is it the type of testing that's done that's been performed by other experts in the field? Does it turn out that this expert is giving opinions on a subject matter that they've never taught about, they've never published on, they didn't even use as a reference in their report? And you'd be amazed, and I'm hopefully going to show you today, how you can take down an expert at a deposition and show all of the flaws in their opinions and what they have in their report. And not only does that help you for your side for advocating and to strengthen your side of the case, but it also shows the other side, hey, yeah, you paid a lot of money. You got an expert with good credentials. Yeah, they wrote a big, scary report, but take a look at what I just did at this deposition. I totally undercut them and I laid the foundation to get them perhaps precluded or limited, or at least look so biased or uncredible that they're going to be a horrible witness at trial. And it can change the trajectory of a case. It could go from a case that wasn't settlable that now is, for either side, for the plaintiff or the defense. Now I see some hands are up, and I'm going to take a quick moment to look at the Q&A. Just want to make sure that the audio and video and everything is still working okay. And I do see posts. Everyone's always asking for materials. Yep, just take a look at the chat and you will see them. Okay. So how do you go about doing this? Now, what I've done is I have in my materials that you have the link to in the chat. You don't need to look at it now, but I've given you sort of two different case studies, expert studies from cases I've had that are closed, public docket. It's all good, so you can use them. And the first one involves a case we had where a lovely lady from Brooklyn decides she wants to get fit, and she gets one of these resistance bands. And it has a handle on each side, and it's a flexible band. And coming with the band is a round ball, a real hard plastic ball that sits in the middle of the band. And it's to be put inside a door jamb. So you put the ball and strap inside, you close the door so the ball's on one side, the straps are the other, and then you could do exercises, pulling exercises, moving, whatever you want to do. And our client, Stella Nicolosi, she was put her foot on the ball as shown in the instruction. She puts her foot in the middle and she goes to do curls. And what happens while she's doing bicep curls, but the ball rolls out from under her foot and slingshots up and smacks her in the eye and blinds her. The plastic ball comes flying right into the eye and she goes blind. And unfortunately for Mrs. Nicolosi, she already had, due to other conditions, lack of vision in her other eye. So as a result of this accident, she is now rendered completely blind. And we were litigating the case against the company Bell Sports. You may have heard of them. They do helmets. They do all kinds of things. And Bell was the company that made this device. And we brought a product liability case against them in federal court. And they came up with an expert. And their expert is a person who I personally have a lot of dislike for, and I have no problem saying this out here to carry on in the internet forever. And his name is Irving Scher. Irving Scher is a biomechanical engineer who's based out in Seattle, I believe, on the West Coast, and his primary area of expertise is ski cases. And I happen to have had him on a prior ski case before Mrs. Nicolosi's wristband case, where he came up with all kinds of testing and data and computer modeling to come up with these opinions as to why our client wasn't injured in that ski case. And then he attempts to do the same type of thing in this case with the wristbands. He was also the expert in the Gwyneth Paltrow ski case against, I believe, Deer Valley. And he used that computer modeling to effectively help the defense win the case because the plaintiff's lawyer in that case, or plaintiff's lawyers, failed to take him down early, failed to move to preclude his modeling, which I have since successfully, in a case that's not here, my third Irving Scher case, a recent ski case, we got all of his modeling and computer modeling and opinions based on it thrown out in federal court. And there's an opinion on that that I'd be happy to share, but it was all as a result of building it up in the deposition, taking them down, and showing that it's not reliable. So in this case, Irving Scher, in Mrs. Nicolosi's case, he serves this report, which you'll see in the materials, that looks really impressive. Charts, data, all kinds of images of the anatomy of the eye, and all kinds of text and paragraphs in his report about the functions of the eye and the parts of the eye, the anatomy. And then he set up this whole testing situation with a platform and a board that you could hit it and it records the loads and the impact. And then he took this device and he pulled it down and he let it go and it would slingshot and hit the board. And when it would hit the board, it would record the loads. And he came up with the opinion that the ball had nothing to do with her injury, that even just a simple strap would have caused the same loads if the strap hit her in the eye, and these are all risks. And that argument that putting this plastic ball on it was a design defect and inherently dangerous, and there were safer alternative designs, did not apply. And that was his argument. So it looks really good. And you see the report and you say, oh, they've got a good expert. Look at all of his credentials. He's a biomechanical engineer. What are we going to do? How are we going to fight this? Then you take a deep breath. You say, all right, well, let's take a look here. And this is when you have to do your homework. If you've ever heard from me, you know one of my mottos is preparation, preparation, preparation. And if ever there's a time to properly prepare, and there are many in what we do, certainly being prepared to depose and question an expert in a federal court case, you've got to start preparing well in advance, weeks, months, because there's a lot to unpack. And what you're going to do in that preparation, the first thing that I recommend is you retain an expert. You need a counter expert if you don't have one already. Most likely you do going into this case. You know what experts are going to be needed or involved. But let's say you didn't know they were going to bring in Irving Scher as a biomechanical engineer. Then you need to retain your own biomechanical engineer and get that report right over to your expert. And then have a meeting with your expert and ask your expert to point out the flaws. And that will assist you in helping you on your own to find the flaws and how to break it down. And here's what I did in that case. I looked through his report, I started doing research, and I found out that there are ways to test for eye injuries, and biomechanical engineering studies were out there and published. And there is actually a model. It's a model of a head, and it's got a synthetic eyeball that you could actually hit loads into. You could punch it. You can throw items at it. You could do all kinds of testing. You could slingshot a resistance band into it. And that eyeball in the head, the synthetic design, will properly record loads. But he didn't do that. He used a board and created his own slingshot mechanism to record the loads against the board. How is that reliable? It may look fancy in a report, but we got into it. And you'll see I enclosed his report, and then I enclosed my deposition of him. So you can look at both. And you could see when I question him, I go at him about, well, why didn't you do that? Why didn't you use this? You knew it existed, and he acknowledges it. Well, it would have taken time, and well, it's really expensive. And I said, oh, is cost a concern? Because you've already charged this company $60,000 for your work in this case. Did you tell them it was going to cost a lot of money and you were concerned that that's why you didn't use it? Did you tell them that this is the proper methodology and they needed to pay that? Oh, no, 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 I didn't do that. This is the first time you developed this model for this case? Yeah, that's right. And it's never been peer reviewed or tested to show it's a reliable way to document forces on an eyeball? No, it hasn't, but I feel very comfortable that it does. So that's one of the things that you'll see I did to take him down. The other is you have to look at the witness's qualifications. If the witness is going to say that they're an expert in something, then take a look. Are they an expert? Is this in their wheelhouse? Just because you're a biomechanical engineer doesn't mean that you have specific knowledge on testing fitness products. And I knew from before deposing Irving Schur that he's a ski guy. He works for the ski industry. That's primarily 90% of what he does is ski accident cases. He's on all kinds of ski organizations. He's involved with the development of ski bindings and boots, all ski, all snow stuff. Nothing to do with exercise bands, nothing to do with eye injuries. So I went at him on that. And you'll see that in the deposition as well, that he never did any of this type of testing before. And so the purpose of doing all of this is to create a foundation for being able to move to preclude this witness, to show the adversary who hired him, hey, look, you may think you were doing a good job spending $60,000+ on this expert, but you're not getting anything out of this expert. And then they're going to realize, well, maybe we should start looking into settling this case. So that's why the depositions are so important. You want to attack credentials. You want to attack methodology. You want to attack bias and credibility. Most of us know that when an expert is being produced, that it's fair game to explore their bias. And Irving Schur does 90% of his work for defendants. To me, that shows that he has a bias towards working for defendants. And how much money does he make a year? Probably 7 figures from what I can tell, because I have his fee schedules and I know how many cases he does. So he's probably making 7 figures a year from the defense bar. It's good business if you can get it. So he's going to keep doing it. These are all great things that come out at a deposition. I gave a lecture a few years ago on when I cross-examined at trial a accident reconstructionist, and one in the Amador case, some of you may remember. And one of the great things was I got him to admit on the stand that he charges $5,000 to review a case and write a report and do an IME, to do an evaluation and write a report. And he charges $10,000 to go to court. And I established that he's worked for the same defense firm for 15 times in the past several years. So I was able to put the numbers together and show all the money he made, 6 figures working for this firm. So you can bring this stuff out in depositions. I didn't have his deposition because it was state court. But now when you can do this in federal court, it really helps because it shows the other side, we may not want to put this witness on the stand. They may not be as strong as we think they are. So good deposition practice can result in really good recovery, or a good result for, if it's not recovery, if you're on the defense side and the plaintiff is posturing with these great experts and you take the plaintiff expert down, that's going to give you more power in the negotiations leading up to any potential trial. All right. Now, the second example that I gave you is a doctor. This was in my client, Mr. Christie's case. He was in his car on I think it was the New York State Thruway, and he was rear-ended by a tractor trailer. And he had back injuries, disc injuries. He ended up having a discectomy and spinal fusion. The defense hired an orthopedic surgeon, Dr. Spivak, to be their expert. And Dr. Spivak wrote a lovely 10-page report summarizing everything and then saying, of course, that his surgeries were unrelated to this accident, had nothing to do with it. He had all pre-existing problems, and it was all degenerative back disc disease. So these are tough, right? Tough cases. You're going up against an orthopedic surgeon who knows the area. Again, I look through the report which I gave you. I see, what is this doctor really saying? What are the opinions this doctor is giving? And what are the opinions he's not giving? And that's important to look at too when you're preparing for a deposition. And you'll see, following his report, the deposition transcript that I gave you, I was able to get great stuff out of him. He was saying it was all pre-existing stuff, but I got him to acknowledge he didn't review one pre-existing medical record. And he independently has no independent basis to believe there was anything wrong with my client's back beforehand. And then I said, well, you're saying that the surgeries weren't causally connected. Are you saying none of his treatment was related to his accident? All of his exams, all of his physical therapy, all these injections he had in his neck and his spine. And the doctor said, well, I can't say yes or no right now. And you'll see I press him on that. Well, why can't you say yes or no? Is that what you were asked to review? You had all the records. You reviewed thousands of pages of records. Well, I don't know. And I said, then you reverse it. And I said, well, is it fair to say that you are not giving the opinion that none of this treatment is that none of this treatment was connected? Are you? You can't say no, this wasn't connected. And he said, right, I'm not saying that. So I was able to at least get a really good concession from this doctor. Our client had a lot of treatment before the surgeries, that it was all causally related, or at least he couldn't say it wasn't. So you have to know what you're trying to get at. You have to set your goals. Always have a goal, always have a plan before the deposition. What do I want to get from this witness? Do I want to attack causal connection? Do I want to show unreliable methodology so I can make my motion to preclude? Do I want to just really highlight bias in this case? Do I want to show lack of knowledge, lack of credentials in this area? Do I want to show just bias against my client, lack of credibility? Okay, I'll give you another few examples. We have a case involving a traumatic brain injury. The defense in federal court produced a witness, an expert neurologist, very well credentialed, very well-known medical school and prominent hospitals in neurology. But when push comes to shove and I started researching all of his publications and what he teaches and all of that, it seems to me that he's more of a spinal process and process of the nerves that go through the body. And when people have, impingement and it's affecting their arms and it's affecting their legs and the systems of the body, I didn't really see anything regarding traumatic brain injury care and treatment, which was the sole focus of our case. And then I spoke to my expert, and that's all he does. He's a traumatic brain injury specialist in neurology. He knows everything. He's published. He's researched. He knows how to read EEGs of the brain, okay? And so then, and he told me that I asked him about the defense expert. He goes, oh, yeah, he's not a brain injury guy. This is what he does. He deals with other stuff. Ask him if he reviews head films, EEGs, and all of that. And and I did. And I got to highlight that he doesn't treat traumatic brain injury patients. Although he says there's nothing wrong with my client. He hasn't published on traumatic brain injuries. He doesn't have brain injury clients. He doesn't know how to read these types. He doesn't feel qualified to read these brain scans. He would refer to someone else to do that. So these are all things that you need to think about to use to your advantage, because then it's going to help you win the case before you even have to worry about trying the case.
First attendance verification code is POD 051. That's POD 051.
All right, I'm back. Let's talk about Rule 702 in Daubert briefly, and then I'm going to get into talking about the actual conducting and defending of a deposition. So another rule you need to be familiar with when you're about to depose an expert in federal court is Rule 702. And Rule 702 talks about the fact that an expert may and can only be used if they have some extra science knowledge that's outside the purview of the layperson, and their opinion has to be based on reliable methodology. Rule 702 specifically says and I'll pull it up and read it for you. Let me see where we have it here. Okay, come on. All right, so what it'll say is that this is specifically Rule 702, testimony by expert witnesses. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not the following. A, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. B, here's where the important is for depositions. The testimony is based on sufficient facts or data. C, the testimony is the product of reliable principles and methods. And D, the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. So there's a lot to unpack here, but the gist of it is, first of all, they need to rely on proper facts. So if they start opining on information like the impact was an rear end impact, you have a biomechanical engineer you're deposing who says it was a light impact and couldn't have caused the injuries that the plaintiff is alleging. But what if they don't have the speeds of the cars at impact? What if they don't have any information on the forces of the impact? What if they don't have skid marks? What if they can't calculate anything? How can they sufficiently form an opinion without those facts, without that data? And just say, well, it looks like it was a big impact, or it looks like it was a light impact, and it only hit the bumper. Well, can photos be enough to make that determination? I would argue they're not. And it'd be really, I'd press them very hard on the fact that there can be serious injuries that can occur when you don't see much damage at all to a vehicle. So in ski cases, for example, or other active cases, you need to know speeds, you need to know locations of fall, you need to know mass, you need to know all these calculations, force, mass, time, distance. And if these experts don't have that in a biomechanical setting or an accident reconstruction setting, then their opinion is worth zero. And so that's an area that you need to question in the deposition. Well, what facts do you rely upon? What records did you review? What data do you have? Can you tell me the speed? Can you tell me the angle? Can you tell me the force? Did you measure it properly? And again, did they apply their reasoning in the proper way? You know, where do you come up with this? Are you citing to a journal that looked at this? Do you have a study that tells you that there can be a light impact and a heavy impact and still no injuries, or that you can have a serious injury with a light impact? Where are you getting this from? Or is it just your opinion because you're being paid to give that? So these types of opinions, which frankly, we see more of in litigation on both sides than not. Usually it doesn't get tested to the mat because you don't have federal court depositions in your case of these experts, and you don't go the distance and make the motion. But if you do, and you prepare your depositions properly of the experts, like I always do, then you are laying a platform for preclusion, very much so, in lots of areas. I have a case pending now where there's a biomechanical engineer, there's a mechanical engineer, and we're talking about whether a structure that my client was on, which tipped over, whether or not it was defective or not. And he writes in his report, and he goes off on a tangent talking about whether or not she could have sustained her injury in this accident and whether the injuries were caused by this accident. But guess what? I know, and now you know, that a biomechanical engineer is not allowed to offer an opinion in court, in a court of law, in front of a jury, about whether or not injuries were caused by a certain accident unless they have medical training. Biomechanical engineers can't even talk about whether injuries are causally related or not. And certainly mechanical engineers can't do a biomechanical engineering analysis. So I've laid the foundation to preclude this witness, this expert, from giving those opinions, because I established at his deposition he's not a biomechanical engineer. He has no medical training, so he can't talk about my client's injuries at all. So if you do this homework, then you can be prepared under Rule 702 to make a motion, because you're saying they don't have sufficient facts or data. They aren't applying well-known and respected principles in this case. And I've asked experts, show me the data. Oh, well, we know. And they go off and off and off on tangents. I know. I'm not asking what you know. I'm asking you what specific data. And you have to press in these depositions to get these answers because these experts are going to be slippery and slimy. I want to talk about that. But Rule 702 will lay the basis for any motion practice. And then if the judge decides to have a hearing, that's what we've all heard of as Daubert, D-A-U-B-E-R-T, based on a case, Daubert versus United States of America. And a Daubert hearing is usually what will follow or happen as part of oral argument. And when I moved to preclude Irving Schur, we did it all on papers. The judge had a hearing. And I got to cross-examine him again. And I didn't even have to pay for it this time because you have to pay for your adversary's experts if you want to question them. But I got him on the stand with the federal judge right there and questioned this expert. And I highlighted and I impeached him from his deposition, highlighted his inconsistencies, and ultimately got his opinions precluded. So you have to build these steps and look at the long game in these depositions. All right, so one of the goals is definitely going to be to move to preclude or limit. All right, now, when the expert is disclosed to you in a federal court case, when you get the report, you also, as part of federal rule practice, Federal Rule 26A2, says that you have to give a report of the expert containing all of the opinions, as well as a list of testimony under oath at deposition or trial in court over the last 4 years, 4 years only. You have to also give their fee schedule and their qualifications and curriculum vitae. Don't just stick all that in a file. Use those. Look up the cases. What kind of cases were they? How did they fare? Did they get precluded? Did it go to trial? Can you get the transcripts? Can you get more information? That's the way you prepare. You get transcripts for witnesses. You get prior reports. You do your homework. How do you get them? I know is going to be a question. Well, you ask other lawyers. And then there are one of the sponsors of the Academy, the Expert Institute, has a whole database on experts. And you can pay them and they will come up with a list of reports and CVs and transcripts of that expert in your case. So I will do that in every case and get everything I can. And then guess what? Your client who is evaluated by an expert, a neuropsych expert, and your client is the plaintiff, and that neuropsych expert comes up with a report that says there's nothing wrong, they're exaggerating and malingering, right? Well, guess what? You do your homework, you may find another 15 reports where this expert finds all these other plaintiffs to be exaggerating and malingering. And then you find out that this expert only testifies for defendants. And all of this, you'll confront that expert with at the deposition. And it just shows how incredible their opinions really are. And it shows your adversary, yeah, this isn't going to look too good in front of a jury if you choose to continue to use this witness. This witness isn't as strong as you think this witness is just because they're going to say what they say in their report. So you need to build up your war chest to go to battle in this deposition and make sure you have everything that you can. Google the expert, do your research. You'd be amazed when you type that expert's name in what you might get. I've had experts come up that had their licenses pulled, that were kicked out of working in New York, that have gotten signed agreements with the Attorney General's office that they agree not to practice. I mean, these are all really good things. You could find out complaints were made against these experts. So these are all great things that you do want to confront them with at their deposition. Now, I did briefly see a question. Someone said, well, don't you want to hold on to some stuff until trial, right? To get that gotcha moment? Maybe is the answer, but I find that if you confront them and show them at deposition, and even if you can do a recorded deposition, which you can put in the notice that you plan to record it, and if they don't object, you can. It just, when you confront them with all of this and take them down at the deposition, they're not going to be able to come up with a better answer at trial because you have them locked in at their deposition. And it's going to show your adversary and show this witness the powerful position you are in. Now, in the little bit of time I have left before we go to Q&A at 2 o'clock, I want to talk about the actual conducting of the deposition itself. Now, one of the biggest things that we all run into is we're asking a question, and the two problems the questioner runs into are as follows. The first, if you have a very obstructive counsel as your adversary, who's blocking, who's objecting to everything, who's directing the witness, don't answer. I'm not going to let the witness answer that. All right. Well, that shouldn't fly in state court, and it definitely doesn't fly in federal court. Again, you've got to look to Rule 30, okay? And Rule 30 will show you what the deal is and pave the way for you. And this is what Rule 30 says, and I want to quote from it because it is very clear about what you can and can't do as far as directing a witness not to answer. So let me just pull this up right here. All right. Come on. I think I have it up here. Yes, Rule 30. Okay. Here's what it says. A person may instruct its opponent not to answer only when necessary to preserve a privilege, to enforce a limitation ordered by the court, or to present a motion under Rule 30d3. Rule 30d3 says, at any time during a deposition, the deponent or party may move to terminate or limit it on the ground that it's being conducted in bad faith or in a manner that unreasonably annoys, embarrasses, or oppresses the deponent or party. The motion may be filed in the court where the action is pending or the deposition is being taken. If the objecting deponent or party so demands, the deposition must be suspended for the time necessary to obtain an order. That's it. So none of this directing a witness not to answer because it's argumentative. Don't answer this. This is harassment. This is not related. It's out of line, whatever that may be. In federal court, and frankly, in most state courts, the witness has to answer the question unless there's a privilege or there's a limitation ordered by the court. And if you want to go in federal court this last step, you better be ready to go, because if you're going to terminate a deposition, because you want to protect some right that you think is being avoided, you have to be willing to know that the judge may not let you resume the deposition and you may have lost it if you're the questioner. If you're the defending party, you may be sanctioned if you terminate the deposition, and you shouldn't have, or costs may be rendered. So I'm going to tell you something that happened with me. I was in a federal court deposition, and my client, there was evidence at the time of the accident leading up to it that morning, he had smoked cannabis. So it's certainly fair to ask questions. But the lawyer started going overhand. Oh, you thought it was all right to smoke before you participated in this activity in the lawsuit? Well, did you think it's okay to smoke before you go to school? Do you smoke weed before you go to your day job? Do you smoke weed before this? And on. And finally, I said, stop. I said, you're harassing. This is way beyond where you're going, and I'm not going to allow it. And I said, and so you either need to move on or we're going to call the court. He says, I'm not calling the court. My experience is the judges don't want to be bothered by this. And I said, well, I'm not letting you ask these questions. So we can either move on and you could ask something else, and then you could apply to the court for your deposition, but we're not doing it. So the bottom line is that the judge was not happy. We basically did terminate the deposition. He said, I want to ask these questions. And the judge gave it to him and said, you cannot ask these questions. She gave it to me a little bit saying, you can't instruct him not to answer. And I said, well, I did it under this rule and I have to protect my client from this, Your Honor. And so the judge went our way, told us to go back, continue the deposition at a later time, and gave very strict parameters on what this lawyer could ask about cannabis. So you need to know the rules of engagement, but don't be afraid to get the judge on the line. If you have a difficult adversary who's blocking or who's asking harassing questions, say, I'm going to mark this for a ruling. Do you want to reconsider now before we get the judge on the line? Sometimes they will, sometimes they won't. And then get the judge on the line. Don't mess around. All right? Have that number ready. Lastly, you'll see in the transcripts I gave you, but many times expert witnesses in a deposition, they're weaselly and slimy, and they're not going to give you an answer, even though you know you have the right question. And you say, and that's true, you never did that, did you? Well, when I do this, I think of that, and they still won't answer the question. Keep asking your question. Get your answer. Don't let them pull you off track. Then I always love it when they don't answer my question and I keep asking it. And then my adversary says, Mr. Smiley, you've asked and answered. You've asked this question 10 times. And I say, I'm going to keep asking it until he answers it. And that's not a proper objection under the federal rules. Asked and answered is not a proper objection. You have to let him answer my question. So don't get taken advantage of. It's your deposition. Get the answers to the questions you need. Have a good outline, stay focused, know what the plan is when you're going into the deposition, build your outline accordingly, have everything organized so you can confront the witness with their other testimony or their reports and get the answers that you want. Lastly, with 1 minute left, if they say they don't want to give you an answer because like, well, that's not what I think happened in this case. You keep saying that it was in the afternoon, and I don't think it was in the afternoon, so I'm not going to give you an answer to that. So what do? What you do is you give a hypothetical. Sir, I want you to, for purposes of my question, I want you to assume it was in the afternoon. Assuming it was in the afternoon, wouldn't you agree that? And then you ask your question. So you have to be able to bob and weave. When they're being obstructive, when they're not giving you a straight answer, you got to keep fighting to get the answer. And if you feel you need to take a break and regroup and you're getting frustrated, take 10 minutes, regroup, call your partner or colleague or boss or whoever and say, they're giving me a hard time. Any suggestions? Call me. I'm always happy to help. I get texts and calls from court and depositions, and I'm always happy to jump in and help because it makes me mad when it happens to my friends like you. All right. So we're at the 2 o'clock mark. If you just want to get your 1 hour of credit, you will get it. Feel free to bail. Otherwise, please stay with me. We've got a half an hour more. We're going to go for another half an hour where I'm going to address your specific questions. There's a lot to unpack here. If I didn't cover something that you want, email me. Sign up for one-on-one with me. I'm more than happy to privately meet, discuss with you, whatever case you have, issue you have, workshop anything, just reach out to me, okay? Because an hour is tight to fit it all in, and I know we're all always hungry for information. So what I'm going to do now is shift gears, and I'm going to go starting all the way at the beginning. Okay, first one from an anonymous attendee. What about pre-depo pushback on the scope of a 30B6 notice? All right, so you serve the 30B6 notice, your adversary pushes back and says, no, we don't have to produce a witness who's going to have knowledge of all of this. Your 30B notice is wrong, it's vague, whatever it is. Well, the answer is look at the case law, look at Rule 30B6, and then you push back. Or you revise your 30B6 notice if your adversary is right, if it's too vague, if it's too burdensome, if it's overreaching, if it's information that is not appropriate, whatever it may be, see if you can tailor it. Reach out and confer. You're required in federal court, and this should be a requirement. It's just good practice. When you have an issue with your adversary or a discovery issue, shoot an email. If it gets tight or tense, pick up the phone. Say, look, I know you're doing your job. I'm doing my job. What problem do you have with my 30B6 notice? Maybe we can work something out because otherwise we've got to go to the judge. And the judge is going to know what we tried to do to work it out. So let's try. Are you willing if I do this, if I remove these 3 items, is that good? So that's what I do, anonymous attendee. You try and work through it. And at the end of the day, you contact the magistrate or the district court judge overseeing discovery and say, we have an issue. We need to pursue this. They're giving us a hard time about a witness or about the 30B6 notice. And we would like the court's intervention and guidance. And that's how I'd handle it. All right. Mr. Krivenko is asking, how do you challenge a judge or clerk's ruling directing a witness during a deposition to answer a question that you believe shall not be answered under the governing law? So you just make a record. I mean, if the judge orders you, doesn't matter what you think the governing law is. And the clerk is an extension of the judge. If the clerk is saying, and they have the power to extend the judge's power and says, you need to do that, and you really think that the law is really contrary, then what you say in the recording is you say, I'm sorry, Madam or Mr. Clerk or Your Honor, I feel that there's case law that's completely opposite to having to have this witness testify, and we'd like the opportunity to brief the issue and suspend the deposition. And see what they say. They say no, You can make your objection on the record and then you can brief it afterwards. That's what I would think would be the proper way to proceed, is I would make your record. I would say, please note that we are objecting to this question under the case of so-and-so, or this rule of so-and-so, or that it's a privilege or a statute. However, we are allowing the witness to answer this question because we've been so directed to allow the witness to do it by order of the judge's clerk or the judge. And that'll preserve you from having the answer come out at trial if need be, which is really the ultimate goal of objections. And the other question that Mr. Kravenko asks is, what are the ways of preserving the record of the ruling on questions that the witness must answer during deposition, given that such rulings are often made orally, over the phone, or on Teams? So when you call a judge for a ruling, you need to make sure to tell the court reporter to take down everything that goes on, so that the court reporter will have the judge's interaction with the litigants in that call. So what I would do is, if we're on a Zoom, like we all are now, somebody agrees to call the judge and put it on speakerphone, and you hold it up near the microphone and make sure the court reporter can hear it, and the court reporter will get everything down. So it'll be preserved. It'll be on the transcript, okay? All right, Stephen Williams, do you ever decline to ask someone questions of your opponent's expert at the deposition so you have a few surprises at trial, especially when you don't have a shot at getting your opponent's expert precluded? I touched on that. For the most part, I go at him and throw in the kitchen sink in the deposition. There's really no reason not to, because you're going to get good stuff. And then you can take it and use it at the time of trial if they choose to put them on the stand. You've got them acknowledging something under oath that you've caught them in. So, you know, obviously it always depends on the facts, what you've got, and maybe there is a benefit to holding certain things back. But for the most part, go for it. Get what you can, because you may not go to trial. And ultimately, if you're trying to get a good resolution in your case, you want to get the good stuff out in these depositions. That's my opinion on that. All right. Anonymous attendee is asking, can a prior recording or a wire of a non-party be offered over his objections? What if he subsequently repudiates prior statements? How can you put these statements into evidence if he doesn't take the stand as a witness? So this is a little bit afield from the topic at the moment, but if the point is, if you have something that, if you have a prior statement recorded of this witness, you set them up at the deposition. You say, isn't the sky blue? And they say, no. You say, well, sir, didn't you previously testify, or didn't you tell my client in a meeting, or didn't you tell whoever, or didn't you give a speech where you said that the sky is blue? And then they'll say, I don't recall doing that. And then you confront them with it. So you did this, right? I had the great one of that. I had an expert in a case where I first pinned him down on something, that this is the primary thing you look for. And then I had him lecturing to insurance companies. I found a lecture online done somewhere abroad on video, and he's up there with a slideshow, and he's showing the first most important thing is this. And our thing was the second. So I said, well, you don't always say it's the first important thing, do you? In fact, when you're speaking to a bunch of insurance representatives, it was the second thing you look at. So always attack a witness at a deposition with prior statements, with prior inconsistent statements. You don't need to save that to for trial. You definitely want to go for it. And that's how you'll get it into evidence. Then you put them on the stand, and then you're using the testimony from the deposition. You don't need the actual document or video you have of them. And you can still use the other document or video if need be at trial. Do I use a checklist, Francis is asking me, for trial prep and trial? Well, yes is the answer. It may not be a pre-printed list I can give all of you that says do this, do that, but leading up for a trial prep and trial, which again is getting off this topic a little bit, we always develop a trial file. We always have a witness list. You always have an evidence list. You always match up what we need to get into evidence with the witness we're going to get it in through. We set our goals for each witness on the stand, in direct and cross. What do we want to get out of them? And you need to start thinking about all of that before you're taking depositions and you're producing witnesses for depositions, because you want to know what they're going to say and if it's going to help you as part of that checklist. All right. What else do we have here? Anonymous is asking, can an attorney for New York State advise a witness at a deposition who is the treating physician not to answer where the witness had brought handwritten note with dates of various events, and this was handed to the questioning attorney at his request, and he would not return the note or a copy of the note to the witness. So again, you cannot instruct a witness not to answer. So that's the easy response to your question. It's not proper for an attorney to direct a treating doctor not to answer. All right. There's no privilege. Again, you have to look at the rules. Certainly in federal court, unless it's pursuant to court order, privilege, or some form of harassment that they're going to make a motion on, they have to let them answer. And if they handed over notes, the person should give back the notes. If you're saying, I'm giving them to you to use at this deposition, or better yet, next time before handing over any notes, make copies of it. Say, all right, hold on. We're going to make a copy, or take a picture of it. It's on Zoom, and email it so everybody has copies. There should never be a deposition where there's only one copy and only one party has it. If it's being used at the deposition, everybody should be able to see it or have a copy of it, okay? Is the objection unduly repetitive instead of asked and answered? No, it's not. Unduly repetitive is not a known objection. Asked and answered is a technical objection, but again, it's just an objection. It's not a basis for having a witness not answer. So if I'm questioning a witness and they're not answering my question and you're defending that witness and you keep wanting to say objection, asked and answered, fine, you can say that, but the witness still has to answer, okay? That's the point. So I don't think unduly repetitive is an appropriate objection. All right, another question. Is asked and answered not a valid objection only for depositions or in actual federal trials as well? No, asked and answered is a valid objection. You can do it at trial. If your witness is on the stand and they ask the witness a question, they give the answer and they get up and ask the same question. Objection, asked and answered, sustained. Move on, counselor. So yes, asked and answered is a good objection to use. All right. Another question. During the deposition, can a witness be asked to mark papers, a physical act, or draw a picture related to a case? Can the lawyer for the witness object on the ground that the deposition is for oral examination? Great question. Great question. Basically, I am of the opinion that you can ask them to mark stuff. You can ask them to draw a diagram. You can ask them to do things like that. You know, that is something that I would like to look at the case law, because that's just my opinion. I believe that a deposition is Q&A. You have it, but sometimes if it's a defect, they say, can you point to the defect for me here? All right. Now, you got to be careful, because if you don't let your witness do that, and while that may be your right, then if there's motion practice going down the line and your witness has never identified it, that may be a problem for you. So you may want to prep your witness. They may ask you, they do, I'm going to let you. Make sure you mark this spot. Make sure it's the spot you've told me is the spot here on this photo where you fell. But I'm of the opinion, and I'm curious what anybody else thinks, because there are a lot of smarter people than me on this webinar, if they're aware of any case law. But my instinct would always be to, I never let them pull out stuff out of their wallet or look things up on their phone in a deposition or write things or draw things. I say, this is a question and answer session only. And I like to keep it that way. All right. Someone's asking if I can discuss the difference between asking questions, seeking legal conclusions in federal court versus state court, and questions at depositions concerning things written in the pleadings. So there's not much of a difference between that I'm aware between federal court and state court where you're asking for a legal conclusion. I think if you're asking a question of law of a layperson, that's not appropriate. But again, it's not a basis to direct a witness not to answer. You make your objection, asking for a legal conclusion. This is a lay witness who can't give an answer to that. Over objection, you can answer if you have an answer. And even me saying that is a little too much. You're not allowed to coach the witness. So you make your objection and then the witness answers, okay? I don't think it's a reason to block the witness or to allow that answer to be blocked. And questions at a deposition concerning things written in the pleadings. Yes, technically pleadings are fair games. So some people like to show a witness a bill of particulars, or sometimes they like to show them something else. I think that's perfectly fine. Have you seen this before? And if the witness says no, then you're done. If they say yes, say, and what was the basis for you looking at it? Did you verify this? Are you the person who verified the bill of particulars? Well, I want to ask you some questions about it, right? So, hey, let's see who's here, maybe making an appearance. All right. So you can show pleadings, but again, if the witness isn't aware of them and has never seen them, and then you can object and say the witness isn't aware, ask your question, move on. Okay. All right. Dee Dee is saying, is it true that you can appeal a decision on a motion about answering a deposition question, but you cannot appeal where you call the judge for a ruling on the spot? Doesn't that make it more advantageous to wait and make the motion and just mark it for a ruling on the record at the deposition? Great question. I don't think a judge's ruling at a deposition is what's appealable. I think what you would do is, if really what you're looking for is being able to compel them to answer the question that they didn't answer. So that's when you would make the motion. And if a judge says, for example, they don't have to answer this, and you think you're really entitled and the deposition got completed, then you make the motion to the court and you say, well, at the time the judge, Your Honor, ruled this way, we are asking for the court to consider, sort of like a renew and re-argue, consider all these other factors that exist that may not be known at the time that that ruling was made, and compel this witness to reappear or answer in interrogatories these specific answers. So there's different ways to do it, but generally, you know, you always want to mark things for ruling, so you can throw everything in for making a motion to compel and then appeal a decision. But yeah, you would need an actual decision if you're looking to appeal something. Okay, and a decision, an oral decision directing an answer, is not appealable as far as I know. So you would need to make some type of motion or request a decision from the court to appeal.
If you're joining us today via podcast, the second attendance verification code is POD 577. Again, POD 577.
All right, Alan is asking, do you ever question your own witness to clarify or expand response to a defendant's question? Is it proper to question your own witness at a defense attorney's deposition of the plaintiff? I've had defense attorneys tell reporter to bill me for my questioning. All right, that's a great question. I'm glad you brought it up. So whether or not to question your own witness who's being deposed, whether you're plaintiff and it's the plaintiff or one of your witnesses, or whether you're the defense counsel and it's a defense witness, that is up to you. That is a strategic decision. For the most part, I do not, 99% of the time, I never ask my witness a question. I'm producing them because the other side wants to ask questions. I don't need to put things out there just to give more opportunity for my adversary to ask more questions now that I've brought something up. It could come to bite you back if you open up the door when they're all done questioning, but you're like, I have a few questions, and you go down a route, they may be like, oh, well, we're going to follow up on that. So be careful what you do. I also had a case recently where I questioned a witness for the defense, their expert, and their expert said something helpful to us, confirmed something for us that they may not have wanted to. And in their report, they said something a little differently. And so their lawyer tried to rehabilitate them and ask them questions afterward, but it's almost like the witness inadvertently doubled down and gave a very strong response, which helped us and ended up hurting the defense even more. So, you know, it was basically unlucky for my colleague on the defense side that, you know, I think he did the right thing by trying to rehabilitate his witness, but he got burned. And it's coming back to bite him, I believe, in a motion that's pending where I quote his expert's testimony. So be careful. As far as the payment amount, yes, technically, if it's my witness and I am paying for the reporter, and then another lawyer, a third party maybe, wants at it and decides to question for more than just a few questions, I jump in and I say, just to be clear, you know, you have to pay for your portion of this, and confirm it with the court reporter. Yes, I'll bill for their pages to them. So technically, each questioning party should be paying for the part of the deposition that they're questioning and not have to pay for everybody else. All right. Question, does object to form, is that a sufficient objection at a deposition to cover any issue to be potentially raised to a court? For the most part, I mean, basically, if you look at the state rules and the federal rules, pretty much you always have a right to object, even at trial. So just because you didn't object at a deposition doesn't necessarily mean you're precluded from objecting or raising a motion later on. However, to be safe, just say objection. You don't need to say what the objection is for. You don't need to say objection of form. You don't need to say objection as an answer. Just say objection. Go ahead, you can answer. Just say objection. That will give you much more latitude. If you then need to make a motion, you say, I objected to this. Because if you object to form and that wasn't really the proper objection, if the objection should have been, let's say, to privilege is the basis, then if you only object to form, they'll say, well, you didn't object to privilege, you only objected to form. But if you say the word objection, it covers all bases. Similarly, on trial, when I have to object, I usually stand up and just say objection. And the court usually will say sustained or overruled. If they ask for the basis of my objection, then I'll give it to them. But usually you're better off just saying objection, because if the judge thinks it's objectionable for whatever reason, you don't have to articulate the specific one until they ask you. So that's just a little practice tip. All right. Let's see. Do I have an opinion whether demonstrating how much an expert is paid actually benefits the defense? For example, a juror could think this expert must be good since the expert costs a lot. That's a nice way to think about it. You know, I guess it depends how you're going to use that. So if it's really an outrageous sum, you know, if they've been paid, this expert's been paid 6 figures on a case, and, you know, you could say, wow, must have been really important to have you on board. They were very concerned. They paid you $100,000. Then I've used it in summation. I had a case once where it was an oral surgical trial, and the defense oral surgical expert wouldn't give me an inch, wouldn't concede anything. I even asked, I said, well, if this was your own child, wouldn't you have referred your own child for follow-up? No need to. And I got out his cost, and he was a very pricey expert, and he made lots of money doing this. And I think in summation, I called him the $1 million man. I was a little younger. I don't know if I do that now, but in summation, I was like, look at their expert, the $1 million man. He wouldn't say anything. He wouldn't give an inch. He wouldn't even refer his own child to make sure that things were okay and refer for further treatment. Come on. You know, what do you think? That's not credible. Why is he saying all that? Because he's getting paid a lot. And why wouldn't he give an inch? You know why, members of the jury. You know why. So you kind of use it that way. But yeah, that's another way to think about it. If the defense thinks, if the jury thinks, wow, they must be good, they paid him $500,000. I don't know. It's a good point. And curious what other people think of that. Can you ask an attorney not speak to his client during the course of a break in depositions? So look, a lawyer is always able to speak with their client, all right? You can't prevent an attorney from speaking with their client. And I've heard otherwise. I've heard them say, well, you can't coach and it's in the middle of a deposition and this and that. So my position is, all right, you have a problem with me speaking with my client during a break, during a deposition, call the court and complain, you know, and see if they want to take you up on that offer. I'm never going to be told I can't speak to my client, ever. And if I need to drag my client out of the room because he or she is going downhill and doing a really poor job and I need to tell them the facts of life, I'm going to do that to save their case. And if I'm not supposed to, then tell it to the judge and you explain to the judge that I saw my client was really at a point of unease and I wanted to make sure. So we took a break and I spoke with them. And I feel it's my legal and ethical obligation as a lawyer to make sure my client is doing okay and feeling comfortable at the deposition. As long as you're not telling them what to say and coaching them on what to say or not to say, there's nothing wrong with it, in my opinion. Am I in my rights as the examiner to refuse to follow up an oral request on the record for documents from the witness with a written request post-deposition? Defending attorneys always ask for a follow-up letter, but I see no reason for that. So yes, I mean, you know, a deposition is not the forum to request discovery. So if my client or my witness is being questioned and they say, well, do you have any documents that may reflect what you just said? And they say, yes, I do. And then the defense attorney says, well, I want call for the production of that, Mr. Smiley. I want you to give that to me. And I say, put all requests in writing. I don't have to respond to an oral request at a deposition, especially when I say, please put it in writing. My job is to focus on defending the witness, asking questions. So yes, you should, if you need discovery, you should follow up in writing with a formal discovery demand. Asking for it in a deposition, I do not believe is sufficient enough and won't be a good basis to move to compel production of discovery. Say, well, I asked for it in the middle of the deposition and look at this page of the record. And that's why lawyers are usually sharp enough to say, please submit all of your requests in writing. And then the response to any motion would be, I told the lawyer, submit in writing. They never did it. That's not my problem. Okay. In a personal injury action stemming from a motor vehicle accident, can a witness be asked about the immigration status? Can we ask the witness client not to answer and mark it for a ruling? So good question. My understanding of the law is, again, look at the rules. Federal court, does it say a witness need not answer questions about their immigration status? No, it does not. Okay, someone who's undocumented has the right to bring a lawsuit under our judicial system. And whether or not they are here under valid certifications, IDs, valid process, or whether they're undocumented or illegal, doesn't matter. They have the right to bring the case. It may matter on other issues, and that would be for a motion in limine. So the short answer is no. They have to answer the question. You can't block that. It is proper to ask immigration status. Now, why is it proper or why is it relevant? It usually gets to the point of where I see it most of the time. If you're making a claim of loss of future employment opportunities, loss of wages, because then you could say, you know, it does go to it. You're arguing 20 years of lost income ahead, but this person isn't here legally. They can be deported. And so we're not going to consider that, and a jury can hear that. So when we've had clients who are not here legally, and there's a case going to trial, we'll make a motion to preclude them from bringing up immigration status as prejudicial at trial, but we would also have to withdraw any future claims of economic loss or inability to work in the future, because then it becomes fair game. And there's case law on this. All right, thank you. Someone posted a case. Looks like the District of DC. The court allowed witnesses to mark up documents during depositions and rejected objections that doing so is improper, saying it helped to clarify the testimony. So there you go. So there's a case. So if you're going to ask a witness in federal court, bring the case law with you. But otherwise, I still think you're in your rights to object if you want to, and see how well prepared the witness is the lawyer is with case law to support it. If I'm in a case like this and I tell my witness not to mark something and I'm in federal court and someone gives me a case law from my jurisdiction, I'm in the Southern District, the Eastern District, the Northern District, District of Connecticut. If they give me something from the Second Circuit or from my district like this, then I will say, okay, you gave me a case law, I'll reconsider. I'm going to let them mark it, because the judge is going to see this transcript. So it doesn't look good to you. It's not a good look, as they say, if you just ignore the law. What you might do, if this is just a court from the District of Columbia, I'd say, well, that was the District of Columbia. We're not in the District of Columbia. It's a different circuit. It's a different district. That law doesn't apply here. Find me something that'll persuade me from our district. So that's how I'd handle it. All right, I think I have room for maybe one more. Right? Someone comments, experts are not clients, so their discussions are not privileged. It could be work product, but therein lies other areas to explore. Do I believe there's a problem for plaintiffs who only use experts who represent plaintiffs? I do. And I think that I always like experts that do work for both sides, because that's where they get the most credibility. I don't like hired guns. I don't use hired guns in my practice. But for example, in my ski cases, my experts are usually plaintiff only. And the reason is because most ski experts don't want to go against the defendants, the ski companies, because that's where they get their business and get employed. So there's a ton of the experts on the defense side, but it's very hard to find someone on the plaintiff side. And there's usually only a few. So I ask them, I'll say, why do you do work only for plaintiffs? And I'll do that in my direct exam, or have them bring it out, or have them explain it if I know the questions are coming up at a deposition, and let them explain why. Some of them have a philosophical reason. I believe that the injured parties need the help. It's always easier for the defense to find somebody. I'm available, but I've never been hired by a defense lawyer. Ask them why. Why don't you do it for the other side? Just prepare them. But I think it's better practice if you're a defense firm and a plaintiff's firm, not to use someone who's always defense oriented. My goodness, how many of you have seen a report from William Head or Jerome Block, or there's countless others? And I get these IME reports from defense counsel, and I'm like, come on, can't you find another expert than someone that's in their 80s who's been doing this for 60 years, 100% for the defense? I mean, it's just, I won't put any weight in it if I get it. But if you hire someone who's a really well-regarded practicing expert who works on both sides and they have valid opinions, then I'll look at it and say, they may have something here, and I'll go back to my expert. But I'm not going to put anything into what these experts say that are hired guns that are used over and over again. And it amazes me why they're still being used, just to make the lawyer and maybe the claims adjuster say, oh, we've got an expert who's going to say this. Because when they get on the witness stand, I'm going to come up with like 1,000 pages of defense cases and go through them all and show the millions of dollars these people have made over the years just being paid by insurance companies to say there's nothing wrong with a plaintiff. All right, so we are at the finished line here. I want to thank everybody for hanging in there with me. Most of you did stay on for the last Q&A, which I really appreciate. Please reach out to me if you haven't already, or even if you have already. You can find me at my email, asmiley@smileylaw. Got my podcast. Click on this link here to get to the books. Everything goes to my charitable causes. And part 3 will be on June 5th. And we're going to talk about actual motion practice. I alluded to a lot of it today. We're going to get into the weeds of motion practice in federal court. So I thank you for your time. If you're not an Academy member already, come on. What are you waiting for? Join us. We got stuff for you to do. You're going to love it. You can take my spot and give these presentations, or do them with me or with someone else, or do them by yourself. But great to see you. Have a great month ahead, and I'll see you all in June. And now we are signing off.